I'm Kirmonika Christian, and I am one of the group members in Group 8. And our scenario was based off North Carolina or Virginia, and it states Casey sues her boyfriend's cousin for accidentally running over her foot with his car. The cousin serves admission requests, one of which asked her to admit that she was drunk at the time. Casey's lawyer gets behind schedule and doesn't respond until 38 days later. The court deems all of the requests automatically admitted. Casey's lawyer knows the jury will see that admission, but in an effort to counter it, he also wants to introduce evidence that Casey's religion forbids her from consuming alcohol. Can the lawyer do that? So first in my research, I have North Carolina and Virginia as my states, and I searched requests for admission. And the J.M. Parker and Sons Incorporated versus William Barber Incorporated requests for admission. Okay, this was filed at the North Carolina Court of Appeals. And the background of this one was the supplier brought action against customers seeking to recover for goods sold and delivered. So the requests for admissions were properly served on customers' counsel. The court did not abuse its discretion and denied customers' motion for withdrawal or amendment of admissions. Admissions conclusively established that customers were liable to supplier for goods sold and delivered. Go down here. Okay, so right here it states where one party fails to timely respond to another's request for admissions, the facts in question are deemed to be judicially admitted. And in order to avoid having requests for admissions deemed admitted, a party must timely respond if there is any objection whatsoever to the request. The failure to do so means that the facts in question are judicially established. So in the next general account, fire and life assurance Corporation versus Cohen case, it says each of the matters of which an admission is requested shall be deemed admitted unless within a period designated in the request, not less than 10 days after service thereof, or within such shorter or longer time as the court may allow on motion and notice. The party to whom the request is directed serves upon the party requesting the admission. Either one, a sworn statement denying specifically the matters of which an admission is requested, or setting forth in detail the reasons why he cannot truthfully admit or deny those matters, or written objections on the ground that some or all of the requested admissions are privileged or irrelevant, or that the request is otherwise improper in whole or in part. And that was from the Supreme Court of Appeals in Virginia. The statute that I decided to use was Rule 36, Request for Admission, Effect of Admission. is the North Carolina General Statutes annotated. And it states that a request for admission, a party may serve upon any other party a written request for the admission, for purposes of the pending action only, of the truth of any matters within the scope of Rule 26B, set forth in the request that relate to statements or opinions of facts or of the application of law to fact, including the genesis of any documents described in the request. Copies of documents shall be served with the request unless they have been or are otherwise furnished or made available for inspection or copying. The request may, without leave of court, be served upon the plaintiff after commencement of the action and upon any other party with or after service of the summons and complaint upon that party. If the request is served with service of the summons and complaint, the summons shall so state. Each matter of which an admission is requested shall be separately set forth. The matter is admitted unless within 30 days after service of the request, or within such shorter or longer time as the court may allow, the party to whom the request is directed serves upon the party requesting the admission a written answer or objection addressed to the matter, signed by the party or by his attorney. But unless the court shortens the time, a defendant shall not be required to serve answers or objections before the expiration of 60 days after service of the summons and complaint upon him. So, our question was, can the lawyer bring evidence about Casey's religion in the admissions request? Being that it was already after 30 days and that it had nothing to do with the original reason of suing, no. The answer is no. The lawyer cannot do that.
Hi everyone, this is Lauren. So, in conclusion, if a court deems all requests admitted due to lack of submission of a response from the attorney, can the attorney introduce evidence that Casey's religion forbids her from drinking alcohol? And our answer was no. In the first Court of Appeals case we reviewed, it is clearly stated that when a party fails to timely respond to another's request for admissions, the facts in question are deemed to be judicially submitted. The party must respond timely if there is any objection whatsoever to the request. Therefore, it is formally admitted to the court that Casey was under the influence of alcohol. Religion has nothing to do with the original reason for suing, so the evidence would not be admitted because it is considered irrelevant. And here are the Blue Book citations.